Okay, and to my immediate right, Councilor Tamisha Civil. And somebody may be joining us, I don't know, somebody said hi or something. It's good to see you, Judge.
Good to be here.
And I'd like to read a letter dated January 7th, 2026, addressed to the Executive Council. Dear Councilors, I'm pleased to nominate Matthew F. King for reappointment to the position of Administrative Judge at the Department of Industrial Access to a 6-year term expiring on May 13th, 2031. Sincerely, Maura T. Healy, Governor. Good to see you again, Judge. If you could give us a little brief summation of what you've been doing the last few years and why you think we should reappoint you.
Great. Well, first of all, I want to thank you all for having me here this morning. Thanks to the governor and Lieutenant Governor for forwarding my nomination. I'm sure you've all seen my resume. I've been in this position now, it'll be almost 7 years. And I enjoy the job. I find a lot of satisfaction. I'm not going to go through all of my, background. I've been basically appointed to the bar in '84. Did some trial work with the District Attorney's Office where I acquired some trial skills, rules of evidence, which do apply at the board. I find that to be helpful. But I got into workers' comp. Kemper Insurance was looking for someone to do litigation. I took it, and I've been doing workers' comp ever since. I've done it on both sides. Worked for that insurance company. I worked for a firm that did exclusively employee work, so I defended injured workers for close to 10 years. I went back to a firm that had multiple insurer clients, but I sought out this position in 2019 and I got it. What I think is, I'm well aware of what the statute is, what its intentions and purpose are, and I try to fulfill that. I think, having done both sides, I think I understand, the motivation, and I understand the attorneys that come before have clients and they advocate for their clients as best they can. That's their job. And having done it from both sides, I understand. My position is to adjudicate it as fairly as I can, and I've tried to do that. I try to get my conference orders out in a timely fashion. I've written a great number of decisions, and I'm proud to tell you I've never been remanded or overturned in all that time. I do take time and consideration and a lot of thought to what I do and why I do it. Hopefully, most of the bar that hears before me is satisfied. And all I can ever hope for people to say is he's fair. He listens, he understands, and he's fair. And when I was practicing, that's all I would ever ask from any judge. Be prepared, be knowledgeable, and apply the purpose of the statute. I know what it's for and what it's intended to do. And I've done the best I can in that regard. And I'd like to continue to do so. So I ask you folks to consider my application, and if you see fit to vote to reappoint me, and I'll continue to do the best job I can.
Thank you very much. Councilor Terrence Kennedy, do you have any questions of the nominee?
This guy here, he's a huge supporter.
Well,
I know, huh?
I appreciate that.
I don't do workers' comp, as everybody knows it. You never saw me up there, okay? You never will, all right? Who will the start now? So there's one guy here who does, and that's that guy. So we all rely on him to tell us who's doing a good job and not doing a good job. And he had great things to say about it. I'm gonna sound like a parrot because he talked to me about everybody, So I'm voting for you.
Good, appreciate
He
it.
told me.
Well, I think you should follow advice.
Councilor Jacobs, any questions?
Just so with your experience, what would you point to as an area that's particularly challenging the DIA right now that maybe could some improvement in process or just as a trend that's happening in the communities that you're seeing that's become a challenge?
Well, I think probably the biggest challenge right now is there's a substantial delay in people getting, quote, their day in court. And it's really no one's particular fault, numbers wise. We're down some judges. I know in Worcester, Judge Dennis Morrow did a great job for many years, is now retiring. I understand Judge Hernandez told me they're gonna reassign someone from another board. Because there's a substantial backlog, and if you are an injured worker and you're not getting any money, having that type of delay is hurtful. It's detrimental. Some of these people, you know, if you're living paycheck to paycheck before you got hurt, it's very difficult. So if there was any way, and if there was some magic solution to this problem, I'd be screaming it from the top of my lungs. I think if we can fill some of the slots, and we have what's called an impartial doctor, under Section 11A. Anytime there's a medical question, obviously both sides can submit their own doctors, but the impartial doctor was put in to break what we used to refer to as the dueling doctor problem. You know, Dr. A looks at the guy and says, oh, this is a terrible thing, and Dr. B, who's hired by the other side. Oftentimes I read these reports and I say to myself, are we talking about the same person here? Did you both? But the roster of impartial doctors is shrinking or stagnant. And a conference order is an automatic right of appeal, and you go to an 11A if there's an issue, a medical issue in dispute. But because the number of doctors is limited, it takes a long time to get there and get a report. I don't know if they can expand that list, and it may be the fees. A lot of doctors, you know, you're going to pay me how much? No, I don't. I'm not going to do that. But you know, that's again, it's a financial situation. If they could get more doctors on that roster and get those reports in, and then we can go to court, and the parties can settle it, or we adjudicate it to a decision. I know a lot of practicing attorneys, you know, comes to me for a conference, I issue what's referred to as a temporary order. And they're, okay, let's just see what the impartial has to say. Oh, okay, make yourself comfortable because it's going to take a while. Which, to both sides, no, it's not favorable if an insurer is trying to modify and they're paying. It's a lot of money that they're spending. But more importantly, as I said, if you're an injured worker and can't earn income to support your family, you're in a tough spot. So if we could do whatever can be done to facilitate the process, that would be helpful.
No, I appreciate that. I've had really great conversations with a number of the folks coming through today, and that issue came up every time. And it sounds like it's a fee that was set a while ago and has not adjusted since. Is it reflective of economics today, and explains to a degree why it's such a challenge to get doctors willing to join that work? And, you know, I represent Western Mass, where just in general, there's a healthcare challenge in keeping doctors, in recruiting and keeping retention for just your everyday primary care situation, let alone a situation like this. And my understanding is it's not just primary care doctors, it's neurologists. It's like every type of doctor or medical issue, there's a doctor that should be on that list who can assess, right? And so the more you get specialized, even more so, it's the same fee for all of them, right? It's like $600 or $650 or something like that. And
it's, like you said, it was set quite some time ago. It's become like, I mean, everything costs more.
yeah,
And doctors, some of them are willing to take that, and some of them have been on the roster for years.
yeah, I'm retiring
In
out.
efforts to recruit more on it. How much you're going to pay me? No, I can't do that. It's
Who sets that fee amount? Is that a legislatively statute?
legislative.
It's, sorry, it's not, in terms within, under our regs, we have to go to public hearing for, obviously, we need the blessing from, you know, people above my paid rate. But yeah, the last time it was changed, I think it was 2011, 12, around that time frame. So it's been a while.
It's been a while.
And it's only we're at 650. And
That's right.
I can, not to interrupt, but we just had a renewal contract process. It's for 6 years. And I had probably between 10, 15 physicians who were on the roster just passed on and said, we just can't. It's 650. It doesn't compete with IMEs or getting 1,500, 2,000. So it has posed a challenge. So
It does. It sounds like a significant problem that needs some attention. But no, I appreciate your answers. Thank you very much. It's nice to meet you, and congratulations on being reappointed.
Thank you. Counselor Civil, any questions of the judge?
Congratulations on your reappointment.
Thank you.
I know our counselor, Leonella, thinks highly of you. And he knows when it comes to mostly practices of advocating for employees who are seeking workers' comp. My question for you, I think we spoke about that briefly, is how would you handle a case? I know the trajectory of working has changed. You have working from home now since COVID has happened. How would you treat a case if someone was injured at home while working from home?
Well, and I recall, we discussed this, I look at it this way, the workers' comp statute, the burden of proof is on the employee. But to fall under a compensable, it must be one arising out of employment. And depending on the condition, caused while you were doing work-related activity. And to me, the fact that you happen to be outside of a traditional workplace, I don't think you're not ruled out. We know a lot of people work part-time virtually. I do. But others, a great deal of their time, they're at home, but they're doing something mandated by your work. And it's the activity you engage in or what you're doing is required by your work, and you develop a condition that's disabling. To say, well, you were at home, it doesn't count. To me, that's nonsense. As I said, you don't see as much, back in the day, data entry was far more prevalent. People literally, they just sit there all day at a computer and type. You develop like carpal tunnel or tendinovitis or at a computer. Well, the fact that you're doing the same thing sitting in your house, now it doesn't count. No, it counts. As I said, every case is individual. It's exactly how you do it, how often you do it, what's the burden. It's the case in every situation. But to say, well, if you're not at the workplace, it's not work-related, even though you're doing work-related activity that led to a diagnosis. And because of what you do, that's what caused this. It doesn't exclude you. There's still the burden of root cause relationship, but me, like I said, arising out of in the course of employment. If you're doing something outside of the that doesn't mean it's not arising out. So I would evaluate the case on its face. What do the doctors say? What's the testimony? All the facts, and look at it quite simply. Is it arising out of or not?
Thank you. You're very qualified for this position. I've been able to look into what the work entails and what you do, and with the mentorship of Counselor Ianella, he has really been a supporter of yours. So,
Well, like I said, I appreciate that, and I appreciate your support as well.
Counselor Dolan.
Thank you so much. It's really good to see you, Judge King. I really appreciate our conversation the other day. And at the risk of being repetitive, I do want to let you know that Counselor Ianella speaks very highly of you. That that means a lot to me. I don't have any questions for you. I just want to observe or to note that I really appreciated what you had to say about the mediation process and the importance of a mediator really understanding all the issues and being very experienced, which I know you are. And I really appreciate public servants who take the work they do seriously.
Well, as you probably become aware, anyone who does comp, all the administrative judges are now permitted to do mediations, where back in the past, you'd have to hire an outside mediator. It could cost you $1,500, $2,000, and everybody had to troop into a law office. We do them, it doesn't cost a penny. I encourage people, maybe we'll try mediation. I think you should. And quite frankly, I have my administrative assistants, if you can fit it in, if they're asking for me, I'll do it. Because it moves the case along. As I said, delay it's bad for the injured worker. It could be not cost effective at all for the insurer. Faster you can, if there's a resolution to be reached, let's get there. So I enjoy doing them because I can speak bluntly to people. That's my personality. I get in a room, I'm just going to tell you what I think. If you don't like it, well then, sorry. But that's it. And I think I've had a pretty good success rate in the mediations I do. I've had attorneys come back and say, geez, my client kind of likes you. He thinks you're a regular guy, and speak bluntly. I don't go in with a robe on expecting it's the ring. We're here to work on your case, not mine, yours. Let's cut to the chase, see what we can do. I said to Omar at some point, you know, why can you, I'll do mediations until I die. I'll never retire.
We may see you back in 2031.
Thank you, Counselor. Counselor Ziegler, any questions?
Thank you, Councilor. Congratulations on your nomination for appointment, and thank you for taking the time to speak with me prior to today. You know, in our conversation, I asked you what was the most important case that you've decided on, and you gave an answer that you gave earlier this morning that, you know, you didn't really pick one, and that you stood on your legacy on not ever being overturned in your decisions, and I think that's powerful. I wanted to ask you just one question. What is, so you clearly have, you know, a great body of experience. What is your mission every day when you go to work?
Interesting question, but I would put it to you this way. I think my function and purpose there is try to adjudicate these cases, but according to our statute and case law. I do say to people sometimes, you know, I don't make the rules. I just know what they are. You know, there's a burden of proof. It's not a tort case. Mediation, you're not suing anybody. If you're entitled to compensation, you should get it. And there's a case that often gets cited when I get closing arguments and legal briefs. I think it's Duv's case. And the sentence, and anyone who does comp sees this, this is the SJC, by the way. The statute shall be interpreted not considered to do otherwise would frustrate its beneficent design. Very flowery language, but it clearly points out this was put in so injured workers wouldn't have to file a suit against their employer, which that's the way it was back in the early 1900s. That would take forever and delays. We don't know how long it takes, and it could literally stop somebody out. It was put in for the benefit of the injured worker. It's not to say you win every time, but comp it's mandatory insurance. If you have employees, you have to have comp insurance, or you'll deal with the trust fund, and you don't want to do that if you're an employer. But they have to pay in. So if there's a benefit of the doubt or question, it's designed to, and I look at it, a lot of cases are very loose. When you say you don't want to frustrate its beneficent design. And I think in most cases, in my experience, people who get hurt and they're out of work for a while, people who have no idea what they do, oh, they're in for a free ride, it's a free check. The overwhelming majority just want to get better and go back. That's what they want. Sitting home is, you know, I get a check every week for doing nothing. That gets tired very fast, especially if you have a family to support. So I think if you can provide them with the medical benefits, whatever treatment they need, well, we're ready to go back to work. They will. So I know what the law is. I know what it's intended to do, and I do my best to apply it that way. I'm not looking, I don't come in and say a predetermined. Every case is a blank slate until I hear it and yes, but that's what the SJC had to say, and we're going to, you know, overturn it. So, like I said, Council, I do the best I can, and to keep doing it just that way.
Thank you. I appreciate your answers, and thank you for your time again. And you're, of course, I don't think it's been said today, but your council is a big supporter of yours. So that goes a long way as well.
Thank you very much. Councilor Paul DiPaolo.
Thank you, Counselor. Good morning. Congrats on your reappointment. I'm sorry I wasn't here for your introduction. This is
That's
the
okay.
I could do with school drop off coming from Worcester, but in this world that I don't practice in, obviously I look at my network of folks who do. So at my firm, with Atty Pollard, our chair today or this morning, Councilor Iannella, Michael Occasion, these are folks I talk to, and they all tell me that I should be confident that workers in Massachusetts are getting a fair shake, being treated with dignity, and then we're not making it more difficult than it needs to be. for them to get what they deserve. And just heard your discussion of the philosophy behind that. So I'm going to be a broken record this morning, but
It was my line.
yeah, I know, but you weren't in the room.
Did I say that earlier?
I'll be speaking on behalf of Councilor Kennedy, the rest.
Back, see if you can say that.
Yeah, so yeah, anyhow, I'm not gonna belabor it with questions. I'm appreciative of the work you do on the board and
Thank you, sir. I
forward to
support
support.
your remarks.
Thank you. I don't have any questions. You know, I'm looking at your resume. Outstanding. This is one of the best resumes, especially the education. I just happen to have gone to those exact same Boston Latin, Boston College, and Suffolk Law School. No, I don't have any questions. You're doing a great job.
Hell of a judge given that.
No, thank you. You're doing a great job. The senior judge speaks very highly of you. When your name comes before us, depending how quick people can be, we're gonna try to do it today. Try to do it today at the assembly. So you got the clue, Omar?
I got it.
Okay, that's it. Is there anyone in opposition to the appointment of Judge King? Then no one in opposition. That will conclude the hearing, and thank you very much.
Thank you all. I appreciate you taking the time to hear me.
We'll conclude the hearing.